Hello students, I am Dr. Harpreet Kaur from Army Institute of Law Mohali. Today I will be discussing with you the topic of judicial review and parliamentary democracy, a symbiotic relationship. Introducing the topic, in the landscape of modern governance, two pillars stand out for their critical role in upholding the rule of law and democratic principles: judicial review and parliamentary democracy. These concepts, though distinct, are interwoven in a symbiotic relationship that balances power and ensures accountability within a state. Judicial review is the power vested in the judiciary to interpret the constitution and to oversee the legality of action taken by the executive and legislative branches of the government. It serves as a check on the powers of the parliament, ensuring that laws and policies do not overstep the constitutional boundaries. The judiciary, through its interpretation of law, can invalidate statutes, executive orders and other governmental actions that are found to be unconstitutional. Parliamentary democracy, on the other hand, is a form of government where the executive derives its democratic legitimacy from and is accountable to the parliament or legislature. The parliament is elected by the people and they represent their will. It holds the supreme legislative power, enacting laws that govern the state and its citizens. The interplay between judicial review and parliamentary democracy is crucial. While the parliament enacts laws, the judiciary review these laws to ensure they align with the highest law of land, that is the constitution. This review process is a fundamental to protection of individual rights and prevention of arbitrary governance. However, this relationship is not without its tension. The concept of parliamentary sovereignty suggests that parliament should have the ultimate legislative authority, free from judicial interference. Judicial review, in contrast, can be seen as a limitation on this sovereignty, as it allows the judiciary to overrule the parliamentary decisions. Despite these tensions, the balance between judicial review and parliamentary democracy is essential for the functioning of constitutional democracy. It ensures that no single branch of government becomes too powerful and that the rights of the citizens are protected against the misuse of legislative or executive powers. Now, I will be coming to historical development and judicial review and parliamentary democracy. The roots of judicial review can be traced back to early civilizations, but its modern conception is often associated with the landmark case of Marbury versus Madison in 1803 in the United States. This case established the principle that courts have the power to strike down laws, statutes and some government action that contravene the constitution. However, the concept of judicial review existed in various forms even before this case. In the United Kingdom, the notion of judicial review developed differently due to the absence of a codified constitution. The UK system is based on the principle of parliamentary sovereignty, where the courts do not have the power to strike down primary legislation. Instead, judicial review in the UK involved the court reviewing the lawfulness of decisions made by public bodies. Parliamentary democracy, with its origin in Magna Carta of 1215, has evolved over centuries. It is characterized by a doctrine that the elected assembly or parliament is the supreme legal authority capable of creating or ending any law. The gradual development of democratic institutions ensured that the power of the monarchy was curtailed, giving rise to a system where the parliament held the ultimate legislative power. The tension between the parliamentary sovereignty and judicial review is a central theme in historical development of many democracies. While parliamentary sovereignty emphasized the unchallengeable authority of legislature, judicial review serves as a mechanism for checking the authority to prevent the violation of fundamental rights and the constitution. In India, the concept of judicial review was incorporated into constitution to ensure the protection of fundamental rights. The Indian judiciary has the power to review both legislative and administrative actions to ensure they are constitutional, which is cornerstone of Indian democracy. The historical development of these concepts has been influenced by philosophical, political and legal thought and continues to be a subject of debate and refinement in legal theory and practice. The historical perspective provides a backdrop for understanding the current dynamic between judicial review and parliamentary democracy. It highlights the importance of balance and the ongoing dialogues between the legislative and judicial branches to ensure the rule of law and the democratic governance. Coming to the constitutional rights and the judicial review. Judicial review is the cornerstone of constitutional democracies, ensuring that constitutional rights are protected within the ambit of parliamentary democracy. It empowers the judiciary to scrutinize and invalidate legislative and executive actions that violates constitutional provisions, thereby upholding the Constitution as the supreme law of land. This principle is exemplified by landmark cases such as Marbury versus Madison. This is of US 1803, which established the judiciary's authority to override unconstitutional legislative act, and Keshwananda Bharati versus State of Kerala of year 1973, which reinforced the basic structure doctrine in India. The role of judicial review in parliamentary democracy is to ensure that the majority's rule is tempered by the Constitution's enduring principles, safeguarding individual rights and minority protection. It compels the legislature to consider the constitutional validity of its action, promoting a culture of legal justification and reinforcing the checks and balances essential to the functioning of democracy. In a sense, judicial review serves as a bulwark against the potential tyranny of the majority, ensuring that the democratic process upholds the rights and liberties of all citizens, thus maintaining the democratic ethos and integrity of the states. Discussing further the judicial overreach versus parliamentary sovereignty. The debate between judicial overreach versus parliamentary sovereignty is a nuanced discourse that delves into the delicate balance of power between the judiciary and the legislature. Judicial overreach is the term used to describe situations where the judiciary is perceived to be encroaching upon the domains of the legislative or executive branches. It implies an active judiciary that goes beyond its constitutional mandate to interpret laws, venturing into policy making or administration areas typically reserved for the elected branches of government. Critics argue that such overreach undermines the principle of separation of power and can lead to a form of judicial activism that may not always align with the democratic will. Parliamentary sovereignty, on the other hand, is a principle rooted in the British constitutional system, asserting that the legislature has the ultimate law-making authority. It holds that Parliament can enact, amend or repeal any law, and its decision cannot be overruled by any other body, including judiciary. This concept is central to the functioning of a parliamentary democracy, where the elected representative exercise the sovereign will of the people. The tension between these two concepts arises when courts, through the exercise of judicial review, invalidate legislative acts deemed unconstitutional. While this serves as a vital check on legislative power, ensuring that laws adhere to constitutional norm, it can also be seen as a challenge to the authority of Parliament, especially when judiciary's interpretation of the Constitution is at odds with the legislative intent. In many democracies, a balance is sought through a system of checks and balances where neither judicial overreach nor the absolute parliamentary sovereignty is allowed to dominate. The judiciary is respected for its role in interpreting the law and protecting rights, while the legislature is recognized for its role in reflecting the will of the people through lawmaking. The Indian Constitution, for instance, embodies a synthesis of these principles. While it does not endorse absolute parliamentary sovereignty, it also guards against judicial overreach by providing for a system of checks and balances. The Supreme Court of India has the authority to strike down the laws that it finds unconstitutional, but this power is exercised with restraint, and the Parliament has the power to amend most part of the Constitution. In conclusion, the discourse on judicial overreach versus parliamentary sovereignty is about finding the right equilibrium where the rule of law is upheld without compromising the democratic principles that empower the legislature to act as a voice of people. It is a dynamic interplay that continues to evolve with the changing contours of law and society. I have different case laws. First is Marbury versus Madison. This is of United States. The case of Marbury versus Madison establishes the principle of judicial review in the United States, allowing the judiciary to invalidate the government actions that violate the Constitution. This case sets a precedent for the ruling of judiciary in interpreting the Constitution and ensuring that other branches of government do not exceed their constitutional authority. The second case is of Keshwanand Bharti versus State of Kerala. The Supreme Court of India in Keshwanand Bharti versus State of Kerala laid down the basic structure doctrine, asserting that the Parliament could not alter the fundamental framework of the Constitution. This case is a cornerstone of Indian constitutional law, balancing the power of the Parliament to amend the Constitution with the judiciary's role in reviewing such amendment to protect the Constitution's basic structure. Third case is of Factor-Tame Limited versus Secretary of State Transport. This is a case of United Kingdom. In Factor-Tame Limited versus Secretary of State Transport, the European Court of Justice established that UK court could suspend UK legislation contravening European law. This case challenged the traditional concept of parliamentary sovereignty in the UK, illustrating the tension between domestic legislative supremacy and the principle of judicial review within the context of European Union law. The next case is Miller versus Prime Minister. Again, this case is of United Kingdom. The United Kingdom Supreme Court in Miller versus Prime Minister ruled that Prime Minister Boris Johnson advised his Queen to prorogue Parliament was unlawful. This case is a modern example of judicial review in action, where the court intervened in a political matter, ensuring that the executive does not undermine parliamentary democracy. The next case in line is Naga People's Movement of Human Right versus Union of India. This is a 1998 judgment. This case addressed the validity of armed forces and whether it violates fundamental rights granted under the Constitution of India. The Supreme Court upheld the constitutionality of AFSPA while also setting guidelines to prevent its abuse, thus balancing the state security need with the protection of civil liberties. The next ruling is Padfield versus Ministry of Agriculture, Fisheries and Food. This is of United Kingdom. The House of Lords held that courts have the authority to review the action of the executive to ensure they are in line with the intent of Parliament. This case is significant as it established that ministerial discretion is subject to judicial review and cannot be used to frustrate the purpose of the Act. The next leading judgment is Pepper versus Hart. This is of United Kingdom again. This landmark ruling allowed the use of ministerial statement in the interpretation of legislation, which was a significant shift in the approach towards statutory interpretation. It demonstrated the judiciary's willingness to consider the context within which the Parliament enacts law, thereby affecting the relationship between the judiciary and the legislature. The next leading case is Jackson versus Attorney General. In this case, the UK's High Court questioned the limit of parliamentary sovereignty in the context of Parliament Act 1949. The law lords opined that there may be limits to the extent of parliamentary legislative competence, especially when the fundamental constitutional principles are at stake. Now, coming to the Balancing Act, separation of power in the spotlight of judicial review. In the grand theatre of governance, the doctrine of separation of powers play a leading role, ensuring that the narrative of democracy does not descend into a tragedy of tyranny. This doctrine, a structural safeguard in an architecture of democratic states, distributes governmental authority among three distinct branches: legislature, executive and judiciary. Each branch is endowed with unique powers and responsibilities, creating a system of checks and balances that is the heartbeat of a healthy democracy. The legislature, the playwright of policy. The legislative branch, akin to the playwrights in our metaphorical theatre, crafts the law that set the stage for societal norms and public order. They are the voice of the people, translating the collective will into scripts of statute and regulation. The executive, the directors of the state. The executive branch take on the director's role bringing the scripts of life through implementation and enforcement. They manage the day-to-day affairs of the state, ensuring that the laws passed by legislature are applied and followed. Coming to the judiciary, the critics of the constitutionality. The judiciary, much like the critics in the world of drama, review the performances of other two branches. Though the power of judicial review, they ensure that the laws and action of the legislature and executive adhere to the constitution's overarching narratives. Judicial review, the spotlight of sovereignty. Judicial review is the judiciary's most potent tool, casting a spotlight on the constitutionality of legislative and the executive action. It is the process by which the judiciary examines the compatibility of laws and actions with the constitution and invalidate those that conflict with the constitutional principles. Coming to parliamentary democracy, the audience's applause. In a parliamentary democracy, the legislature is supreme, reflecting the will of the electorate. It is the audience applause that guides the play with the elected representative acting on behalf of the people. However, this supremacy is not absolute. It is tempered by the constitution, which is the ultimate script of the land. The interplay, a performance of balance. The interplay between the judicial review and the parliamentary democracy is a delicate dance of balance and restraint. While the judiciary has the authority to question the constitutionality of the legislative acts, it does so with deference to the principle of legislative supremacy. Similarly, the legislature, while sovereign, operates within bounds set by the constitution, mindful of the judiciary's role as a guardian of constitutional right. Breedlove versus Gossett, United Kingdom case. This case addressed the issue of parliamentary privilege and its limit. The court held that it could not interfere with internal proceedings of the parliament, emphasizing the autonomy of the legislative branch and the principle of exclusive cognizance. Sine versus Con of 1968, United Kingdom. In this case, the court considered whether it could review the legality of government spending in light of UK's obligation under international treaties. The court's decision not to intervene highlighted the limit of judicial review in matter closely tied to parliamentary proceedings. In case of Naga People's Movement of Human Rights versus Union of India, the Supreme Court of India extended its review jurisdiction to cover the Armed Force Act, a legislative act, underscoring the judiciary's role in scrutinizing legislation that impacts the fundamental right. Conclusion, the final curtain call. The doctrine of separation of power with judicial review at its core ensure that the play of governance is performed according to the Constitution's directive. It is a testament to the foresight of the framers of the democratic system who understood the need for a balanced distribution of power. As the final curtain fails on each act of governance, it is separation of power that ensures the show goes on, preserving the integrity and vitality of the democracy. The next point is parliamentary privilege and judicial review. In the vast ocean of democratic governance, the ship of the state must navigate the complex waters of parliamentary privilege and judicial review. These two concepts, while distinct, are deeply intertwined in the fabric of parliamentary democracy, each playing a crucial role in maintaining the balance between the different branches of the government. Parliamentary privilege, the shield of legislature. Parliamentary privilege refers to a special legislative immunities and protection afforded to members of the legislature. It is a shield that guards the freedom of speech and debate within the hall of parliament, ensuring that legislature can perform their duties without fear of interference or reprisal from outside the legislative chamber. This privilege extends to matters such as freedom from arrest in civil cases during session and the non-questioning of debates or proceeding in parliament. Coming to judicial review, the compass of constitutionality. Judicial review, on the other hand, is the power of judiciary to interpret the constitution and assess the validity of legislative and executive actions. It acts as a compass guiding the ship of the state by the stars of the constitutional principle, ensuring that the laws passed by the legislature and the action taken by the executive are in line with the constitution's directive. the interplay, sailing in symbiosis. The relation between parliamentary privilege and judicial review is delicate dance of mutual respect and restraint. On one hand, parliamentary privilege is essential for the legislature to function independently and effectively. It allows legislature to engage in open, robust debate without the chilling effect of potential legal consequences. On the other hand, judicial review serves as a check on the legislature, ensuring that parliamentary privilege is not abused and that the action of parliament remain within the bounds of the constitution. Breedlove versus Gossett. This case affirmed the principle of exclusion cognizance, recognizing the autonomy of the legislative branch and its proceeding. We have a Supreme Court case of Raja Rampal versus Speaker of Lok Sabha and others. This is a 2007 judgment. The Supreme Court of India defined the scope of parliamentary privilege and its relation with judicial review, ensuring that privileges are not misused to the detriment of the constitutional right. In a case of P.V. Narasimha Rao versus State 1998 judgment, this case is also known as JMM bribery case, initially established that member of the parliament who accepts bribes but followed through with voting or speaking in the house as agreed were protected by parliamentary privileges. However, this decision was later overturned, emphasizing that bribery is not protected by parliamentary privileges. Quixote Holhan versus Jacques and others. This case examined the scope of judicial review in relation to the anti-defection law. The Supreme Court held that the laws was within the power of the parliament to enact that the speaker's decision under the 10th schedule is subject to judicial review. In case of M.S.M. Sharma versus Shri Krishna Sinha and others, the case dealt with the conflict between the right of freedom of speech and expression and the parliamentary privilege of non-publication of its proceeding. The Supreme Court upheld the privilege of Bihar Legislative Assembly over the fundamental right to freedom of speech and expression. Searchlight newspaper case. In this case, the Patna High Court held that the publication of expuned portion of assembly debate was a breach of privilege. However, the court also recognized the right to publish fair and accurate reports of assembly proceedings as part of fundamental right to freedom of speech and expression. Conclusion. Steering steady. As the ship of the state continues its voyage through the ever evolving seas of democracy, the principle of parliamentary privilege and judicial review serves as essential navigation tools. They ensure that legislature can perform its function without undue interference while upholding the constitution's supremacy. It is this intricate interplay that keeps the democratic process vibrant, responsive and true to its foundation principle. Now, I will be discussing center-state relations and legislative competence. In the intrinsic tapestry of Indian federalism, the thread of center-state relation and legislative competence are woven with precision, guided by the Constitution of India. The balance between the union and the state in legislative matters is fundamental aspect of parliamentary democracy, and judicial review plays a pivotal role in maintaining this equilibrium. Now, discussing the legislative framework. The Constitutional delineates the legislative competencies of the centre and the state through three lists in the 7th schedule. First is the union list, the state list and the concurrent list. The union list details subject on which only the parliament can legislate. The state list specify the areas under the exclusive purview of state legislature, and the concurrent list includes subject where both the centre and state can make the laws. Judicial review, the arbiter of competence. Judicial review emerges as the arbiter when dispute arises regarding the legislative competence of the centre or the state. The higher court, particularly the Supreme Court, are often called upon to adjudicate on such matters, ensuring that the demarcation of powers is respected and that neither the centre nor the state overstep their constitutional boundaries. In case of State of West Bengal versus Union of India, the landmark case affirmed the supremacy of union in the matter of national importance and the principle of federal supremacy under the constitution. S.R. Bomai versus Union of India, a significant judgment that outlined the limit of the centre's power to dismiss the state government under Article 356, reinforcing the federal structure. The next heading is Minority Right and Representation. In the vibrant tapestry of India's parliamentary democracy, the concept of minority right and representation is woven within the threads of judicial oversight. The Indian Constitution is a living document that embodies the ethos of democratic governance, ensuring that the voice of minority is not drowned out by majority. This delicate balance is maintained through the mechanism of judicial review, which empowers the judiciary to scrutinize the constitutionality of legislative and executive action. Now, coming to the constitutional safeguards. The Constitution of India enshrines several articles that serves as a bulwark against discrimination and uphold the right of minorities. First is Article 14, which ensures equal protection of law and equality before law. Second is Article 15, which prohibits discrimination on ground of religion, race, caste, sex or place of birth. Next is Article 16, which guarantees equality of opportunity in public employment. Article 29 and 30 protects the cultural and educational right of minorities, allowing them to preserve their language and culture and to establish and administer educational institutions. Coming to judicial review, a protector of minority right. The Supreme Court of India has a vigilant guardian of minority rights through landmark judgment. TMA Pai Foundation versus State of Karnataka, it's of 2002, the court reaffirmed the autonomy of minority educational institution and laid down the guidelines to prevent the commercialization of education. The S.R. Bomai versus Union of India case underscored the importance of secularism as basic feature of the constitution, asserting that the central government cannot dismiss a state government for not adhering to its interpretation of the secularism. Representation in number. Despite constitutional protection, the representation of minorities in political and public sphere present a mixed picture. Religious composition as per United Nations report shows 80.5% Hindus, 13.4% Muslims, 2.3% Christians, 1.9% Sikh, 0.8% Buddhist, 0.4% Jain and 0.6% other. About 25% of the Indian population belongs to scheduled caste and scheduled tribe communities, and a similar proportion of seats are reserved for them in the parliament. Women's representation in the Lok Sabha is less than 15%, despite them constituting about 50% of the population. Through these constitutional provisions, case law and statistics, it is evident that the Indian judiciary plays a pivotal role in safeguarding the minority right within the framework of parliamentary democracy. The courts, through judicial review, ensure that legislative and executive branch do not overstep their boundaries and infringe upon the rights guarantees to the minority. This interplay between the judiciary and legislature is fundamental to the functioning of a democracy that prides itself on diversity and inclusivity. Next heading is emergency power. Emergency powers and judicial review are significant aspects of the Indian Constitution that ensure that state can effectively respond to crisis while protecting citizens' rights. The Constitution of India in Part 18 provides the emergency power that allow the President to declare three types of emergencies: national emergency, state emergency and financial emergency. National emergency is given under Article 352. A national emergency can be proclaimed if the security of India or any part thereof is threatened by war, external aggression and armed rebellion. This proclamation can be challenged in court on the ground of malafide or that the declaration was based on wholly extraneous and irrelevant facts as established in the case of Minerva Mill versus Union of India. Next is the state emergency given under Article 356, also known as President's Rule. It can be imposed if the President receives a report from the Governor of a state or otherwise that the governance in a state cannot be carried on in accordance with the provisions of the Constitution. Next is financial emergency given under Article 360. It can be proclaimed if the financial stability or credit of India or any part thereof is threatened. Judicial review. The power of judicial review allows the judiciary to assess the constitutional validity of legislative acts and executive orders, including emergency proclamation. The Supreme Court has played a crucial role in interpreting these provisions. In ADM Jabalpur versus Shivkant Shukla, the apex court controversially held that during the emergency, a person's right to not be unlawfully detained could not be enforced. However, this judgment was later criticized and is considered a low point in the history of Indian judiciary. SR Bommai versus Union of India is another landmark judgment where the court laid down the guidelines to prevent the misuse of Article 356 and protect the federal structure of the constitution. Case studies. The emergency declared in 1975 is a significant case study. It saw a drastic curtailment of civil liberties and alteration to the constitutional framework to favor the ruling government. The 38th Amendment Act of 1975 made the declaration of national emergency immune to judicial review, but this provision was subsequently deleted by 44th Amendment Act of 1978. These provisions and judicial reviews highlight the dynamic between the state's need to respond to emergencies and the Indian judiciary role safeguarding the democratic values and human rights. Creamy layer concept. The creamy layer concept is a pivotal element in India's reservation policies, particularly concerning the other backward classes. It was the first articulated in the landmark Supreme Court judgment of Indrasani versus Union of India, also known as the Mandal Commission case. The court upheld the government's decision to provide a 27% reservation to OBCs, but introduced the creamy layer criteria to exclude the more affluent and better educated members of the OBCs from availing of the reservation benefit. Judicial examination of the creamy layer concept. The judiciary has consistently examined and refined the creamy layer concept to ensure that reservation benefit reach the truly backward member of society. In the Jarnail Singh versus Lakshmi Narayan Gupta case of 2018, the Supreme Court reiterated the need to apply the creamy layer principle to prevent the affluent members of SC and ST from availing the benefit meant for genuinely disadvantaged. This principle is rooted in the fundamental right to equality, ensuring that the reservation benefit do not get monopolized by a small section of backward classes who are already well off socially, economically and educationally. Concluding my topic, I would like to say the criteria for determining the creamy layer have evolved over time. Initially, the income ceiling was set at 1 lakh in 1993, which has been periodically revised to reflect economic changes. As one of the latest updates, the income ceiling stand at rupees 8 lakh. The Supreme Court has directed the factors such as social advancement, education and employment must be considered alongside economic status when identifying the creamy layer among the backward classes. The creamy layer concept is a testament to the dynamic nature of India's reservation policy and its judicial oversight. It exemplifies the judiciary's role in balancing the objectives of the social justice with the principle of equality, ensuring that the benefit of reservation policies are distributed to those who need them the most. I hope you enjoyed the lecture. Thank you and have a nice day.